Hello, everyone, and welcome to our webinar on what impact the post-Brexit trade and cooperation agreement agreed on Christmas Eve will have on digital services. I'm Adam Rendell, a partner in our IP and Media group, and I'm joined by colleagues Vicky Weiberg on movement of people, Chris Jeffrey is going to speak on data, Tim Strong on jurisdiction, James Stewart on VAT, and Zuyang Zhu on IP. There are a few of us because there's a lot to cover, and there's a lot of you tuned in, so let's get cracking. A couple of points on housekeeping. We're on video, but you're not, so you're not visible to each other or won't be in the recording. If you've got any questions or comments, please ask them in the Q&A box, which is at the bottom of your screen, and we'll do our best to pick them up either as we go along, or we'll follow up with you afterwards. Let's start by stepping back in time and remind ourselves of the then Prime Minister Theresa May's vacuous statement of Brexit means Brexit. What she should have said, I think, is that Brexit means hard Brexit. And that's what we see in the TCA, and I'll explain that in a few ways. The UK is no longer part of the single market, and it doesn't benefit from country of origin protections for services. The fundamental freedoms of goods, people, services, and capital have all ended. The UK is now a third country relative to the EU, and without especially privileged access to the EU's market for its digital services. The TCA contains very few rights on which digital services can rely to facilitate their cross-border activities. For future plans, such as the establishment and operation of multi-territory services, a rule of thumb could be to treat the UK and EU as separate territories. For sure, as of today, the laws in both the UK and EU are aligned. So a relatively harmonised or one market approach can still be taken to legal compliance. However, the divergences have already started in some key areas, movement of people, for example. They may shortly be imposed on us, on data, another example, and they'll soon start to arise as EU member states start to implement key digital legislation, which won't be adopted in the UK. The Omnibus Consumer Law Directive is an example of that. So there will be a double regulatory burden, or rather multi-territory digital services will be faced with working out how they can simultaneously comply with two sets of regulations and to try and find a common approach. One imminent example of that struggle, I think, will be the overlapping proposals that come out of the UK on online harms, and they've come out of the EU in its Digital Services Act. They're both aimed at the same goal, which is of increasing the responsibilities placed on online intermediaries, but they take different approaches to get there. That all means, to my mind, that any no-deal planning that had been carried out remains very relevant. I thought it'd be helpful to outline briefly the main sources of our new body of Brexit law. We start with the European Withdrawal Act 2018. That repealed the European Communities Act in 1972 and converted EU law as it stood at the moment of exit into UK domestic law. We then had the withdrawal agreement that was agreed in October 2019 and avoided our sort of first no-deal cliff edge. It remains in effect, and it deals primarily with transitional matters, for example, trademarks. It contains the Northern Ireland Protocol, and it provides for the status of EU citizens. We then had the European Union Withdrawal Agreement Act 2020. That implemented the withdrawal agreement in domestic UK law. And then that took us to the Trade and Cooperation Agreement, agreed on Christmas Eve, and that sort of forms a discussion of, forms the focus of our discussion today. The European Union Future Relationship Act 2020, that was passed at breakneck speed on the 30th of December, and that implements and gives effect to the TCA. There have been a raft of topic-specific fixing statutory instruments which are now in force. They amend primary and other legislation to make it work post-Brexit. And to help solve any confusion, the UK government has produced a raft of guidance available at the gov.uk website, and that gives some pretty high-level but pretty useful pointers on what to do. And helpfully for the legal profession, it frequently refers to the need to take legal advice. There's also equivalent EU Commission guidance. That's more detailed and technical, but it comes with a health warning from my perspective, which is that it understandably doesn't reflect the steps that the UK has taken to fix its law to deal with Brexit problems. 3 concepts come out of that legislation, which we're going to be hearing a lot of in coming years. The first and probably the most practically important is retained EU law. That was a concept created by the 2018 Withdrawal Act. It's essentially all EU law that's been converted into UK law and covers things like EU regulations and Court of Justice case law. It's also worth noting, though, that there are some exceptions to that general principle. For example, the UK has effectively proactively repealed some EU law, which would otherwise have become retained EU law. The removal of the EU's content portability regulation is a relevant example of that. The UK has also excluded some core EU concepts, such as the Charter of Fundamental Rights, supremacy of EU law, and the ability of private actors to sue the UK government for failure to implement EU law, known as Frankovich damages. The second category is relevant separation agreement law. That was created in the Withdrawal Agreement Act 2020. That's effectively the now directly effective withdrawal agreement dealing with issues such as citizens' rights. That separation agreement is supreme over other domestic law whenever passed, including the Withdrawal Act. And finally, we get to the law arising out of the TCA. Let's call that Future Relationship Agreements Law. And that's the body of law that arises out of the domestic implementation of the TCA. And finally, before we get on to movement of people, and this is one for the legal geeks amongst us, and I firmly class myself in that category. What Section 29, Section 29 of the Future Relationship Act, what it does is truly remarkable. To my mind, it's going to be sort of the Adele of Brexit law. It's going to be known only by its first name, known as Section 29. It gives the TCA a new form of direct effect. It automatically implements the TCA whenever modifications are required, so far as the agreement isn't otherwise implemented, and so far as that implementation is necessary to comply with the UK's obligations to implement the TCA. It's potentially very far-reaching because it requires us, in every instance to which the TCA is relevant, to firstly review what the TCA provides, secondly, compare it with existing UK law, and finally, identify whether that UK law requires amending. And if it does require amending, Section 29 has automatically amended it already. That's remarkable, in my view. But its remarkable nature will, however, likely be mitigated in practice for 2 reasons. One, it's subject to any actual attempts to implement the TCA, so its significance should reduce over time. And secondly, the TCA should, in very large part, reflect existing UK law without needing Section 29 to amend it. Having said that, I can already think of parts of IP law where there may be some impacts. But on that cliffhanger, I'm going to cut now to Vicky, who's going to take us through the impact of the TCA on movement of people. Vicky.
Thanks, Adam, and hard maybe to follow the Adele of the future, but I will do my best. So in this section, we're going to spend a little bit of time looking at the movement of people and the impact of the last few months on that. It's actually obviously something that's had a really immediate effect, as we'll all know, because only, 13, 14 days ago, the end of the right to free movement came about after a lot of planning and a lot of advice that we've been given. We finally started our new world. So what does that actually mean? It has a couple of impacts. Firstly, that if you as a company have a new European, so that's EU or the other countries such as Norway, or Luxembourg, Switzerland, if you have new arrivals into the UK from the 1st of January, then they are no longer able to come into the UK under the right to free movement, and you will have to apply for a sponsorship visa for them. And that will incur quite a lot more cost than it would have historically, and we'll look at what that means. It also has a second impact, and that is that for EEA nationals who were in the UK before the 31st of December, they have to apply for a pre-settled or a settled status by the 30th of June in order to be able to remain in the UK and to continue to have the right to live, work or study here. So two big implications of the end of the right of free movement. So you may be a company that already has European nationals, EEA nationals in the UK. Many people have already made their application for settled status or pre-settled status. Pre-settled status is an application that someone would make if they have been in the UK for under 5 years, and settled status is the application that you would make if you've been in the UK as an EEA national for more than 5 years. You make these applications on a digital app, which is available widely through by download. It's a free application. Originally there was a cost, but it's now a free application, and it's relatively quick. For most people, if you have been working in the UK and you have a national insurance record, you don't have to upload documentation as part of the application. If you don't have a national insurance record, for example, you're relatively newly arrived in the UK, or you've maybe studied here and then you started working, you may have to provide documentation as part of the application. But it's something that everybody who is an EEA national who's been in the UK since the end of last year will need to apply for. And as a company, you will need to check their application or support them, and also maybe help them and be able to recognise these applications in the future. So in addition to people coming into the UK, we also wanted to look at business travel, as this is obviously going to be something that really impacts on a lot of people. And just before I get to that, we've had a question just to confirm that Irish nationals are exempt from these rules. There are pre-existing legislative arrangements for Irish nationals. So if you have an Irish citizen employee, they don't have to make an application for pre or settled status. So business travel in Europe from the start of this year, it's twofold. So travel for European nationals, EEA nationals into the UK, and also for British nationals into Europe. So the rules are relatively similar in that you are able to make a trip into the UK if you're an EEA national as a visitor. You don't need a visa. You're allowed to come in here for short trips. So, for example, business meetings, maybe coming in to interview somebody for a role in the UK, coming to meet suppliers, clients, that sort of thing. Holidays, obviously, you won't need a visa in advance. When you arrive, you will have a visa potentially stamped into your passport. You may not if you can use the e-gates. There are a list of permitted activities, which are essentially the ones I've just described. So business, kind of standard business activities. Also, the Home Office and the Border Control will be looking at the intention of the person travelling. So if somebody is coming into the UK regularly for short trips, they may expect to be asked questions about their reasons to be in the UK. And it may be that for those people, it's helpful to provide them with, for example, an invitation letter which explains why they're going to be in the UK, and that may be something they can then present if they are asked questions. They may be asked, for example, for evidence they're going to be leaving the UK, so an onward ticket, for example, for the flight they're going to take out, something like that, at the point you are able to travel. The trips into the UK don't have the same kinds of day counting rules as we would have for UK nationals going into Europe. So many of you will know that going forward, British nationals travelling into Europe will be caught by the day counting Schengen rules. So that allows 90 days out of every 180 to be travelling in Europe, and that's across all countries. So if you travel regularly, you have to be very careful not to be spending too much time in Europe. In the UK, we don't have those same sorts of rules. Each trip or each visa you're given would be for up to 6 months. But as I say, the Home Office and Border Control will be looking at intentions. So if somebody comes in for 4 months and then leaves and a week later comes back for another 4 months, They may be questioned about whether they're truly a business visitor or actually going to be working in the UK. Similarly, similar rules about business visitors and business permitted activities in Europe, because the rules in Europe will be reliant on each country. It's always important just to look at the country that you're going to be travelling into or your staff are going to be travelling into, and double checking any particular rules that a particular country may have, but standard business visitor activities should be fine. And just a reminder, the days permitted to be in the European kind of Schengen area are 90 days out of each 180 days. So it's a bit strange. You look at a 6-month period and then you kind of start again. So for example, tourism, short occasional trips are fine. If you have somebody who's travelling into Europe on a very regular basis, have to be just careful that you're not exceeding that 90 days out of the 180. I've had a question, and I'm not going to be able to have time to answer all the questions because we have, as Adam said, a lot to get through. But there are rules in relation to, for example, European nationals and generally anybody visiting the UK. On the Home Office website, there's a list of permitted activities for visitors, which sets out exactly what activities a business visitor is able to do in the UK. So in addition to the rules for EA nationals who've been in the UK since before the end of last year, the government and the Home Office also decided to use this opportunity to review our UK immigration system. And there was a lot of press coverage that you may have seen. So this has been described as the new points-based system. Actually, the points-based system has been in place since 2008. So it's really I'd say kind of a revision of the points-based system rather than a new system entirely. We still have 2 types of what were historically called Tier 2 visas. We have now a skilled worker visa that replaces the Tier 2 general route, and that's typically for lateral hires or new hires. We also have an ICT visa, which replaces the Tier 2 ICT visa, and that's typically for short-term working transfers into the UK of existing group employees. Similarly to a question we had before, these routes are for non-British and Irish nationals, and also not for people who have either settled status. So as you remember, those are people who have already been in the UK before the end of 2020, and also not for people who have indefinite leave to remain in the UK. So that might be a non-European national who's spent time in the UK over 5 years. So these are for other people. In order to sponsor somebody under the skilled worker regime or under the ICT regime, your UK company needs to have a sponsorship license. And if you already have a sponsorship license that was in place before the end of November 2020, then it will automatically convert to cover the new systems as well. If you have staff members who hold a Tier 2 general visa, then when they come to extend the visa, they will automatically extend into the skilled worker system, and the time will be amalgamated for future settlement applications. As was the case before, people are accruing points under these visas, but the points have been changed slightly, and we've listed those on slide 11 here. So all applicants need a certificate of sponsorship, which is a document setting out information about the role you will sponsor that individual for. They also, under a skilled worker visa, need to show that they can speak English to a required level, albeit that now GCSE and A-level qualifications can be used for that test. And also we have 20 additional points for the salary. Now, these are tradable points, by which we mean for people who are higher qualifications, so maybe a PhD holder, you don't need as many points for salary. You don't need the higher level of salary. So it may be particular skilled role can vary depending on qualification level. The other thing that's really important to know is that as of the start of December, for skilled worker visas, we can only rely on base salary. So those of you who may have sponsored a visa using salary and also allowances, we can't do that anymore. Under the skilled worker visa route, it's just base salary. The skilled worker route is really good, in my opinion, for employers. It has had a lot of really beneficial changes. So The first one is that the minimum salary that you need to pay somebody under this route has decreased relatively substantially, down from 30,000 to 25,600 a year. It may be that the skilled role that you want to sponsor has a higher minimum salary, but if not, that's quite a big change. That goes hand in hand with the fact that actually now for skilled worker visas, there's a lower skill level. So you can sponsor people who have a role which is about the same level as maybe an A level rather than a degree level. Also, the government have removed the requirement to complete RLMT, and that was the mandatory 28-day advertising to show you cannot fill the role from the UK workforce before you issue the visa. Now, there is some question mark about that because we do still have to show that a role is genuine before we're able to sponsor a visa. And there's a lot of question marks about how you do that without advertising. But the requirement to tick the boxes of the RLMT, which was very onerous, have gone. Also, we have no cooling off period, and that was a big problem under our old regime. What that now means is that if you have an employee who is on an intra-company transfer visa, rather than them leave the country and have to wait 12 months to switch into the skilled worker, they can switch from within the UK straight away without the cooling off period. And that's been a really great change, in our opinion. There's also the removal of the 6-year cap. So historically, you could only apply for visas for up to 6 years in this category. And then you either had to apply for settlement or your employee would have to leave the UK. Going forward, you can keep extending your visa. You have a removal of the settlement salary and also removal of the 10% shareholding cap as well. I just had a quick question in relation to biometrics for skilled workers. So amongst the many changes that the Home Office have introduced, they have said that European nationals moving forward will be able to submit their biometrics, and that, for those who haven't had the pleasure of a visa application, are the photographs and fingerprints for an application will be submitted via an app, so much like the settled status process, and rather than in person at a biometric Home Office appointment. So that's also a very good change, I think, especially in these times where centres are locked down. So in addition to the skilled worker, so that's the replacement for the Tier 2 General, we still have the ICT route. On this one, not much has changed. So salary, the same minimum level, 41,500 or higher in the SOC code, the skilled worker code. We can continue to use allowances. So if someone's coming to the UK for, say, 2 years and you want to pay them a housing allowance or a cost of living allowance, we can rely on that to meet that salary level. But as I said, we can't on the skilled worker. The skill threshold is the same still, so it has to be degree level, not the reduction to A level. So higher skill threshold, higher salary. You can switch, as I mentioned, so you can switch from Tier 2 ICT into skilled worker from within the UK. That's great if someone comes across and decides they want to stay. Maybe their family likes it here and they want to stay. You can switch, and that allows that route settlement. If you stay in an ICT visa, you can't settle. And on top of that, you're limited in the amount of time you can spend here. So 5 years out of 6 if you're a low earner, 9 years out of 10 if you're a high earner, and high earner is earning over about £74,000. People say to me, why are we going to use the ICT route? Well, you don't have to evidence English, which may be helpful. It's still typically going to be a bit quicker, and the paperwork that you have to prepare is less onerous. So there are reasons to use this route, but for a lot of people, the flexibility for the skilled worker route is going to be really advantageous. So sort of traps, things to look out for, and sort of what you could be doing now. It's really important that if you think you might need to sponsor workers going forward, and some of you may be used to transferring European workers into the UK, you look at whether you have a sponsorship license. And if you do, does it cover your full organisation? A lot of companies apply for a sponsorship license and then they realise that it's been a really long time since they've looked at that sponsorship license and it just isn't up to scratch anymore. You may have acquired organisations, you may have, set up new overseas offices. Is your sponsor license correct? Do you need to make an application to expand it? If you don't have a license, think about applying for one. They last for 4 years, and you can use them to sponsor more than one worker. So they're very good and very flexible, and you might find, particularly moving forward, that it's handy to have that flexibility in your recruitment arrangements. If you have EA nationals who are in the UK and have been working here since before the end of last year, there's some real merit in supporting them, making sure that they know that they have to make their pre or settled status application. Have they done it? Do they need support? A lot of people have, but there's an awful lot of people who haven't done that yet. And it's a very easy way to support your workforce, and particularly when everyone is working remotely at the moment. You should be thinking really about your recruitment needs for 2021 onwards. When you're looking at whether to sponsor somebody, think about, do they have an alternative visa route? They may already have that settled status. They may be in the UK as the dependent of somebody. That there could be various ways that they could work in the UK. If not, they're probably going to need a sponsored visa. For any colleagues that are going to transfer to the UK for a short period of time, they may still need a visa. So anybody who's coming to work in the UK, or vice versa, going from the UK to work in Europe, will need a visa. It's not based on the length of the time, it's based on the activity. So if they're working, probably need a visa. And within that, it's important that you're working with your hiring managers to understand the principles of the new rules. So there's highly likely to be delays in transfers. It's not as simple as arranging for someone to pop in the following week. It can take weeks to get a visa, particularly at the moment. There's COVID interruptions. Overnight, we heard that a lot of the priority processes from the US, for example, have been postponed for now. So there's a lot of change all the time, and it can take a long time to, things change when you're in the middle of a process. You may need more budget. So for a 5-year visa, for a skilled or an ICT visa, you're looking for a large company at about £10,000 in home office fees alone. So it's a lot more expensive. You may need to think about your budget. You need to think about your compliance with your sponsor duties. If you hold a sponsor license, you have lots of duties. The Home Office are going to be looking closely at these in the future, and it's important that you make sure your license is compliant. And because of that drop in the skill level required, particularly for the skilled worker visa, you may find that lots more non-UK nationals do apply for junior roles. Historically, you may have decided you didn't want to spend that £10,000 fees on sponsoring them, but going forward, you might have a race discrimination risk if you choose not to sponsor somebody solely because they would need a visa. So there's lots of things to think about and to be taking some advice on. Obviously, things will change. We're only a couple of weeks into this new process. So that's all for me. I'd like to pass on to my colleague Chris, who's going to talk to you about the data implications.
Thanks, Vicky, and hi everyone. So yeah, just one slide on the GDPR consequences of Brexit, which I've headed up Life as a Third Country, because of course that's what's happened here. We've effectively, and this was the whole objective of Brexit, of course, carved out one member state to become a third country. But that may make it sound like UK companies don't have to worry about GDPR anymore, and that categorically isn't the case. So what's happened, as with much of EU regulation, as part of the withdrawal agreement and the regulations that have followed, the UK now has its own self-standing version of GDPR. So practitioners like me are starting to talk about UK GDPR and EU GDPR. The UK version is pretty much an identical copy and paste of its European cousin, with a few obvious tweaks. So its territorial application is the UK, for instance. Rules about data transfer out of the territory refer to transfers of UK data outside of the UK rather than outside of Europe as we're used to. Now, some pro-Brexit politicians, not in government, have started to talk about GDPR as one of a long list of European regulations that perhaps the UK might diverge from over time. But crucially, there's no indication yet from government that there's appetite to do that. So the real action here is around data transfer, and so let's dive straight into that. Because we've now got two versions of the GDPR, one for the European Union and one for the UK, one of the most impactful areas of GDPR, transfer out of the territory, now raises questions for the travel of data in both directions. So both from controllers and processors within the EEA transferring data to the UK, and UK controllers and processors transferring it into the EEA. Now, let's take them one by one. For transfers Europe to the UK, technically the UK is already a third country by dint of having left the Union, but the good news is we've got a grace period, at least for 4 months, extendable for a further 2, during which companies do not need to be putting standard contractual clauses or BCRs or whatever it might be as a data transfer mechanism. That period specifically selected so that the UK's adequacy application can be considered. And for those not familiar with GDPR, an adequacy application is something a third country can make to the European Commission in Brussels, where they essentially say, listen, I know we're outside the EU, but look at our laws. They're close enough to what you have within the European Union that you should effectively whitelist us. You should say that we're adequate, and then European data can freely be processed within our territory without the need for the standard contractual clauses and other mechanisms, etc. So the UK's done that, as you might expect, given the volumes of data transferring across the border, but it's still with the Commission and it hasn't been heard. The 4 months is they think they'll have enough time to do it, extendable for 2 in case a decision either way is not made within those first 4 months. So adequacy would be great. Adequacy would, in a way, for this data transfer issue, mean there isn't a massive difference on this one issue between being in the EU and not. And you might say, well, you can't get greater alignment between the EU and the UK because we basically copy and pasted the same rules. But it's not in the bag, and we can't assume that that adequacy application will be successful, mainly because the same reasons that killed Privacy Shield way over in the US on the other side of the Atlantic, the intelligence agency access to data would for the first time be considered by the Commission in the UK context. So there's a little bit of a risk that the legislation behind GCHQ's ability to intercept and monitor communications might cause a problem for the adequacy application. We don't know. Practitioners are split. My sense is that political momentum behind the deal will probably mean the adequacy application will come. So that's it. What does that mean in terms of companies who are in Europe but have either affiliates or processors or data centers in the UK? Well, many have already looked to do standard contractual clauses. If you're halfway through that, I'd probably push that to conclusion. The UK regulator, the ICO, is recommending that certainly by the end of April, that would be the end of the first 4 months, people ought to have a mechanism in place so you don't have a period where your transfers are exposed. Looking at it the other way round, what if you're a UK company and you're transferring data you're responsible for to a supplier, a vendor, a data center, a group company in Europe? Well, the good news there is that the UK government has recognised the whole of the EEA, so the EU plus, as adequate for UK GDPR purposes. Now, they've said rather cryptically they'll keep that under review, but again, I guess everything's under review in a sense after Brexit. That's the purpose of the exercise. So we're not worried there's an imminent change going to come to that. Already, though, in practice, in terms of what businesses are doing, because often global businesses will have some kind of data sharing document, contract, maybe full-on binding corporate rules to legitimize their transfers out of Europe to the US, to the Far East, to Australia, wherever it might be. If it's not painful to pull the UK under those pre-existing arrangements, my advice is you actually may well just go ahead and do that anyway, if it's not a ton of extra work and the lift is manageable. So that's the big one, I think, data transfer. Other issues for some companies, existing binding corporate rule applications. This tends to be the really big multinationals. It's the gold standard of data transfer mechanisms. For those who have it, if you've got an application in with the ICO and it hasn't been granted yet, the UK regulator, you need to find a European regulator now to hear it so it can actually apply and protect your transfers from the UK to the rest of Europe rather than just within the rest of Europe, as it were, to other third countries. So you may need to find another regulator on the continent to speak to there. UK and EU reps, just before I wrap up, this is an area of GDPR we've always had. The notion that if you're subject to GDPR, but you don't as an organization have your own presence on the ground in the EU. Let's say US headquartered company is doing direct-to-consumer e-commerce sales to European individuals, doesn't have a subsidiary on the ground, doesn't have a branch, none of its own people. GDPR has always said, in that instance, you should appoint someone else who the regulators and the local individuals whose data you collect can ask questions of, can make complaints to, can make an audit request, etc. Now, it's quite well complied with in Germany and certain of the other more conservative privacy countries, but otherwise largely ignored. The key thing now is you at least have this obligation in theory. If you're a UK company processing European data with no presence in the EU, you should appoint an EU rep somewhere in the European Union. And there's quite a lot of third parties who can provide that service. Flipping it the other way around, it's also the case, regardless what happens about adequacy, it's got nothing to do with it. If you're a European Union country and you're processing data of UK consumers, but you don't have a UK presence, you should have a UK rep. And of course, you end up in a slightly odd position. If you're in neither territory and you're processing consumer data Europe-wide, including the UK, you should have a rep in both. Now, I think the reality is that unless you've done a really good job of GDPR compliance, you may not have thought of the rep issue in the first place. So, I wouldn't have it right at the top of your list where you've got a lot of work on other, maybe more pressing, more high risk in practice areas of GDPR to work on. And then last thought, becoming a third country has some knock-on effects in some of the detailed internal and external documentation that GDPR loves and drives in such volume. So privacy policies and statements, internal to your own employees, external to consumers and customers, your ROPA or Article 30 record, all of those now should list the UK, assuming you're a European-based company, as one of the third countries to which you transfer data. So a number of things to think about there. And with that, I will hand over to my colleague, Tim.
Hello, everyone. First, just to say I'm sorry you can't see me, but someone put a drill through the internet cable outside the front of my house this morning, so I'm having to dial in. Hence, I'm asking Adam to please move the slides on for me. So, Adam, could you, I hope, move us to one which says what we had, and we can take a quick canter through jurisdiction, enforcement, and applicable law. So, assuming, fingers crossed, that we're all looking at what we had, just to recap, for governing law, we had the Rome I Convention, which governed contractual obligations, and Rome II governed non-contractual obligations. For jurisdiction, we had the recast Brussels regulation, and for enforcement of judgments, we had the recast Brussels regulation. And the effect of all of those rules was to ensure that governing law jurisdiction was recognised, choices in contracts were recognised throughout EU member states, and that the enforcement of judgments was a straightforward process throughout the EU. And I've just added, don't forget the EU service regulation, because we had that to facilitate the service of proceedings within EU member states. So, Adam, if you could move on to the next slide, please, which is what we have now, and it is truly a hard Brexit for jurisdiction and enforcement. For governing law, fortunately, there's no real change. We have, in the UK, enacted Rome 1 and Rome 2 into domestic law, and in the EU, Rome 1 and Rome 2 will oblige the courts of EU member states to recognise contractual choices of governing law for contractual and non-contractual obligations. So no real change there. For jurisdiction and enforcement, the Brussels recast regulation has fallen away. Now, for the UK, for enforcement here in England and equally in the other UK jurisdictions, this is probably not going to make an enormous amount of difference. We tend to respect the party's choice of jurisdiction, and we have a flexible approach to enforcement. The real issue here, if you're embroiled in proceedings, is what happens if you want the proceedings to take place here and your opponent tries to thwart that by bringing proceedings in the EU, and what happens if you get a judgment here and you then want to go and enforce it in the EU. So, in summary, we have what I've called the HCCCA. It's the Hague Convention on Choice of Court Agreements, and it applies to exclusive choices of jurisdiction in contracts. Otherwise, if you don't have an exclusive clause in your contract, you have to revert to private international law, and I'll come on in a second to what that might mean. For enforcement, if you have an exclusive jurisdiction clause, you can take the benefit of the Hague Convention on Choice of Court Agreements and take your resulting judgment into Europe, and it will be enforced in a relatively straightforward process. Otherwise, you will be reliant on local law. And again, I'll come on in a second to explain that in a little more detail. There is a Hague Convention on the service of legal proceedings as well, which applies, which all EU member states are parties to. The process for service is not quite as simple as under the EU Service Directive, but in practical terms, it'll make no real difference. Adam, if you could please move on to the next slide. I'll take a slightly closer look at the Hague Convention on Choice of Court Agreements. So the EU is a signatory, and the UK was a signatory by virtue of membership of the EU, and with effect from the 1st of January 2021 has acceded in its own right. So the HCCCA will be enforced by the courts of all EU countries. And what that means is that the courts must decline jurisdiction in favour of the state specified in the jurisdiction clause. So if your clause says the parties will exclusively bring their disputes to the English courts, if someone tries to start proceedings in France, Germany or wherever, those courts will be obliged to stay the proceedings. As I said, a simplified process of recognition and enforcement of resulting judgments. There are one or two pitfalls to be aware of. First concerns clauses, jurisdiction clauses concluded prior to the 1st of January 2021. In the UK, we have enacted legislation which says we treat ourselves as having been signatories to this convention ever since the EU signed up some years ago. But the EU courts, it's yet to be seen whether they will take the same approach. To be safe, you need to assume that the EU will only recognise the UK's accession from the 1st of January this year, and therefore it may not enforce a jurisdiction clause in a contract concluded prior to the 1st of January. There's been talk about contracts being restated, for example, to try and get around that requirement. Again, there's no certainty that the courts of EU countries will recognise that a restatement is a new agreement for that purpose. So there's a potential issue there. And beware what we call asymmetrical clauses, where one party has to bring proceedings in one country and another party can choose a different country or is perhaps not subject to a choice. In the UK, we are prepared to see one of those clauses as exclusive, where it says that one party must bring proceedings in one particular country, But we know, for example, in France, they don't like those clauses, and it's quite possible that EU courts would not consider any aspect of those clauses to be exclusive and enforce them. If we could please move on, Adam, we will have what if the Hague Convention does not apply. So for jurisdiction, private international law will determine jurisdiction. I haven't got time to go through the details here. I can do it in follow-up if anyone would like to. But basically, whether the English court will accept jurisdiction or whether an EU court will is going to depend on factors connecting the case to the jurisdiction, where the relevant events took place, where the witnesses are, where the documents may be, for example. And it may depend on which court is, as we call it, seized first, where proceedings are either first issued or served. It's quite complex, and it does mean there'll be less certainty. For enforcement, local law will apply. So you want to take a judgment to Germany, German law will tell you what you have to do to enforce it. Go to Poland, it'll be Polish law. It will take longer, it will be more costly. And in some countries, it may be quite challenging. In many EU countries, it may actually mean issuing new proceedings and effectively having the matter reheard. It's not ideal. What I would tell you is I've been practicing for nearly 28 years, and I'd only once ever had to take a judgment from the UK and enforce it in another country. It's more of a theoretical than practical benefit. Adam, if I could have the next slide, please. You should be seeing practical solutions. So if you're thinking about your commercial contracts and what you should be doing now in light of Brexit, the obvious one you could have is an exclusive jurisdiction clause, so you have the benefit of the Hague Convention. An alternative is you could decide to provide for disputes to be resolved by arbitration. Some of you will be familiar with arbitration, some won't. For those that aren't, that may seem a step too far, but arbitration means very easy enforcement throughout the EU because all member states are signatories to something called the New York Convention, which operates like Brussels recast did for the enforcement of arbitration awards. It makes it very simple indeed. That said, arbitration involves making some other choices which you would need to consider carefully. For example, cost can be more expensive than court proceedings in some countries. It's less expensive than court proceedings in others. There are likely to be limited rights of appeal. You may not wish to limit your rights of appeal. Again, if people have particular questions about arbitration, I'm happy to pick them up afterwards. I don't really have time to cover all the issues there. And a third way is to include in your contract a provision for an agent for service of process in England. On that basis, jurisdiction will be established here based on presence. It makes it easy to serve the proceedings. It makes it quick to get the proceedings up and running so that the English court is first seized. And also, the English courts have in their armoury something called an anti-suit injunction, which would stop a party trying to frustrate that jurisdiction clause from carrying on with proceedings in another country. Finally, a very brief word about what the future might hold. The UK has applied to accede to the Lugano Convention. The Lugano Convention 2007 is between the EU, Denmark, in its own right, Switzerland and Norway. It provides a very similar regime to the Brussels recast regulation, both for jurisdiction and enforcement. And I think the expectation is that the EU will probably allow that accession within a few months, in which case some of the problems we've been talking about will disappear. And whilst I haven't written it down on there is actually a Hague Convention on the enforcement of court judgments, which has been concluded. It's not a solution for the next year or two. I think there are only 4 countries which have acceded at the moment, and they don't include any EU ones, but that's on the horizon too. That's a bit of a counter through. I'm obviously happy to pick up in questions. I won't be able to do it via the chat box, but at the end, any questions people have. My final point would be to say, I've been talking about the commercial situation. There are some exceptions for consumers, which I don't have time to deal with here, but again, we could pick that up afterwards if people needed to. And thank you. And with that, I will hand, I think it's back to Adam to talk about digital service regulation.
Thanks, Tim, and hi again, everyone. The impact of the TCA on digital services. I think we can skip quite quickly through what the TCA does for digital services. In short summary, not a lot that's going to make a day-to-day practical difference. It's focused more at the kind of country-to-country international treaty level about how law can and can't develop. There's a key digital service, though, key service that it's not in scope of the TCA at all, though, and that's audiovisual services. So all the planning over the last few years that's been undertaken by multi-territory broadcasters who'd previously been licensed in the UK by Ofcom, that planning to re-establish themselves in some way in the EU, that's got to come into effect to enable that broadcast, and particularly the digital aspects of that broadcast, to continue. But picking up on the proposition that the TCA is mostly about what the party's law needs to say, there's a few points to call out in the TCA. There's a commitment to ensure cross-border data flows, custom duties are prohibited, neither party can require prior authorization of digital services solely because it's provided online. Contracts has to be the ability to conclude contracts by electronic means. There's recognition of the importance of enhancing consumer trust, so deceptive commercial practices, for example, need to be prohibited, and users must have effective protection against unsolicited direct marketing. One final point worth flagging in the TCA context is that there's been a lot of political discussion about this level playing field between the UK and the EU, but there aren't any level playing field restrictions on digital regulation. So regulatory freedom for the parties is not limited to that extent. What I think is more important to think through, though, is what the TCA doesn't do. We've talked about cross-border country of origin elements not applying, but those elements in the e-commerce directive no longer apply. So for services established in the UK, compliance with UK e-commerce laws won't be enough to give them passported access into the EU. They'll be subject to and have to comply with the local laws on, for example, online information, advertising, shopping, and contracting in each state of destination. One basic example of that is the German law obligation to provide certain information on a website when offering services in Germany, the so-called imprint law. For non-EU companies, such as those in the UK, German law applies when they provide their website to German customers. That law requires, for example, information on the website about the person who's authorized to represent the service provider. That's normally the CEO. An infringement of that, sounds a relatively minor requirement, but it's still a requirement that constitutes an unfair practice, which can be enforced by competitors or interested bodies under German law. Conversely, the UK has, for now, unilaterally preserved the freedom of EU-established services to continue operating in the UK without needing to comply with the additional UK requirements. But the government has said that it intends to remove that country of origin principle from our legislation and bring EEA service providers into the scope of our law. But let's think about what impact all these principles may have in practice. Let's assume that services are already compliant with UK and EU law and that any relevant local law divergences have already sort of come out of the woodwork. And in my experience, when I'm helping services launch and operate across key markets in the EU, they're likely already to have taken some measure of local law advice in those key markets on things like consumer protection, advertising regulation, platform liability, and so on. Consumers will still be able to sue services in the countries where the consumer is domiciled rather than where the service is established. So the risk of local law impacts on multi-territory services exists already and is going to continue. That multi-territory advice that I mentioned is typically built around the harmonised EU position and then local input on how local implementation or practice deviates from it. Now the UK will start to deviate more from the EU position. That deviation will increase over time. So it seems that the practice of obtaining multi-jurisdictional advice will need to continue, but with more focus on the UK. A quick note on the geo-blocking regulation that prevents services from discriminating between consumers based on their location, although it doesn't apply to media services. For example, that no longer applies in the UK, but for a UK service operating and selling services into the EU, the services have still got to comply with the EU law, so can't discriminate, for example, between customers based in France compared to how they treat customers based in Germany. And final point on digital service regulation is that the TCA is silent on intermediary defences. So both parties retain freedom to strengthen or weaken the immunities, protections available to intermediaries, such as host providers. That's me done on digital service regulation. I'm going to flick on to James to pick up on VAT. James.
Thanks, Adam. Good afternoon, everyone. I'm just conscious of time, so I'm just going to skip ahead and dive straight into some discussion on digital services and VAT. Now, when we talk about digital services in the VAT context, what we're talking about are electronically supplied services, so things like web hosting, online supplies of music, advertising space on a website, as well as radio and television broadcasting services and telecommunication services. We're not talking about just everything which is dealt with online. So if a lawyer advises via email, that's not a digital service, or a sale of goods online. So we're really just focusing on things like electronically supplied services. Now, the EU and also the UK have special rules to determine where digital services are treated as supplied. And the reason you need to know where they're treated as supplied is that then governs which VAT system is going to apply. Now, the rule here is that digital services on B2C supplies to consumers are treated as made where the consumer is located. And the impact of this, and this is a rule we've had for a while, is that if you are a business providing digital services across Europe, potentially you would have to register for VAT in all of the different EU member states because you're treated as making supplies wherever your consumers are located. Because of that, the EU has an optional what's called the mini one-stop shop, or MOS, and this is to help compliance obligations for these digital services. And the way broadly it works is that as a business, and this doesn't only apply to EU businesses, any business worldwide can register under this, you register under MOS in one EU member state, and then that allows you to report your sales, effectively report the VAT on all your sales across Europe just in that one member state. So it's a kind of simplification process. Now, the impact of Brexit on digital services and MOS is that the UK, you could previously have MOS registration when the UK was a member state. That's no longer available. And this can have an impact not just on UK businesses, but businesses outside Europe and within Europe. So I've just put a table on the screen, and just to kind of briefly chat you through that. So if you're a Europe business, then you can no longer use your MOS if you are providing services to UK consumers, because the UK is now out of that system. So if you're a European business providing digital services to UK consumers, you're going to need a new UK VAT registration for that. On the flip side, if you're a UK business, you can't have this MOS registration anymore. So you've got a couple of options. You can either get a new MOS registration in an EU member state, Ireland might be popular, for example, or you can have separate registrations in each of the EU member states where you have consumers. For non-UK, non-European businesses, so for example, a US business selling digital services to EU consumers, if that business currently has a UK MOS registration, then again, it won't be able to use that. And so it's going to need to find a new jurisdiction in the EU to have its registration, or have the separate registrations. At the same time, if that business, if we take our example, the US business, is selling digital services to UK consumers, it's also now going to need a separate UK VAT registration to do that. Now, a quick point on timing, because there's some immediate action points coming out of that. If businesses are looking for a new MOS registration, then they should be looking to do that by the 10th day of the month, effectively following their first sale. So because of the way this interacts with the UK coming out, that's generally going to be the 10th of February next month, 10th of February 2021, if you want to do your registration. So that's kind of the main impact for digital services coming out of Brexit. There's nothing in the TCA that kind of keeps the UK within the MOS system. Now, I've also included a bit on e-commerce because we're starting to see some kind of articles on this. The big takeaway, or the big new change, because the UK is now so-called, kind of free from the EU VAT system, the UK has brought in some new rules on goods entering the UK, so-called low-value goods entering the UK from both Europe and outside of Europe. And the key point here is where the goods are valued at £135 or less. And there's also some interaction between these rules and where goods are sold through an online marketplace. So I just wanted to very quickly touch on those new rules. Now, the key the broad point here is that where you have overseas businesses selling goods into the UK, and those goods are £135 or less, then the idea is that the UK is switching the tax collection point from the point of import to the point of sale. What this means in practice is that actually potentially the seller is the one that's required to register for UK VAT and account for UK VAT to HMRC, the UK tax authority. This doesn't necessarily apply where you've got the customer as a UK VAT registered business, but certainly where you have consumers, overseas businesses now need to be aware of these new rules. Now, in terms of the interaction with online marketplaces, where you have an online marketplace which is facilitating a sale from an overseas seller to a UK customer, then the online marketplace itself can be deemed to be making that supply for VAT purposes, meaning the online marketplace is the one that is potentially required to charge the VAT. If the goods are already within the UK at the point of sale, this is generally going to apply to B2C supplies. If the goods are outside the UK at the point of sale, then it's going to apply again potentially if those goods are £135 or less. So online marketplaces will now have additional compliance burdens. They're going to need to monitor where the goods are located at the point of sale. They're going to, if those goods are outside the UK, consider whether they are £135 or less in value. And they're also going to need to understand whether their customers are VAT registered. So just to bring that together in a case study, how this potentially is going to impact businesses. So let's say we've got a French business selling goods to customers in Great Britain. I should have mentioned at the start, the one point, again, also to be aware with all of this is that Northern Ireland does have different rules for goods. Northern Ireland is effectively staying within the EU VAT system as well. So this example, we're just looking at a French business selling goods to customers in England, Scotland, and Wales. And let's say they sell those goods both directly to customers and via online marketplaces. And let's say those goods are located in France at the point of sale, and the value is £135 or less. Now, if they're selling those goods directly to customers, and they're selling them directly to customers that aren't VAT registered, then that overseas seller is now going to be required to register for UK VAT and start charging UK VAT. There's no threshold there, so it's pretty much as soon as they start selling goods into the UK. If they sell via the online marketplace, then those goods being sold to UK consumers, leaving aside UK VAT registered businesses, it's then the online marketplace that's required to charge the VAT. So essentially, if this French business just didn't want to register for UK VAT and have those obligations, it would need to sell exclusively through the online marketplace. I hope that's been helpful as a quick canter through the key changes coming in for digital services and e-commerce. And with that, I'm going to hand over for some discussion on IP.
Thanks very much. And again, conscious of time, I'll try and rattle through fairly quickly. The first point to note on IP is that the TCA itself doesn't give rise to any immediate practical impacts. So the UK and the EU both affirm their commitment to their existing international treaty obligations, and the minimum standards set out in the TCA for IP protection largely reflect existing UK and EU laws. The TCA does, however, allow potential for future divergence. This is due to a mixture of the fact that it only provides for minimum standards, it's silent in many areas, and there are some areas where the parties have expressly reserved for themselves freedom to determine their own laws. And those are interesting in particular in signalling areas of potential future divergence. And one of these, an important one, is the exhaustion of IP rights. Both the UK and EU will be free to determine whether and under what conditions exhaustion will apply. This is particularly interesting since the EU previously tried to commit the UK to a national or regional exhaustion regime and to maintaining the current EU position that exhaustion of copyright doesn't apply to digital content. Now, the fact that this wasn't accepted by the UK doesn't necessarily mean that the UK government is planning to bring in a system of international exhaustion or extend exhaustion to digital content. But it does mean that the UK is free to independently consider the economic and policy arguments for supporting a broader or a narrower regime. The government will be consulting on exhaustion early this year, and if this is something that's important to your business, you may wish to consider contributing to that. Another general point to note is that the key provisions of the Enforcement Directive are included in the TCA. And this includes not only provisions around evidence and remedies, but also the general principles that enforcement measures should not be unnecessarily complicated or costly, should be effective, proportionate and dissuasive, and should avoid the creation of barriers to legitimate trade. So whilst, as Adam mentioned, the TCA is silent on online intermediary liability, the general principles that intermediaries often try and rely on in the face of IP claims about hosted content do remain applicable. Moving on now to copyright in particular, there are a few areas of potential future divergence indicated in the TCA. First, the agreement is silent on the types of work that can qualify for protection, allowing potential for the UK and EU to develop different laws which might be relevant in particular to works by non-traditional authors. The parties expressly have freedom to determine different rules as to the term of protection for certain types of work, and these include musical compositions with words, works of joint authorship, and audiovisual works. The only requirement as to copyright exceptions in the TCA is that they comply with the Berne three-step test, i.e., they're restricted to certain special cases, do not conflict with the normal exploitation of the work, and do not unreasonably prejudice the legitimate interests of rights holders. This allows the UK to adopt exceptions beyond those in the closed list provided in the InfoSoc Directive, including potentially by bringing back a public interest defence that was developed under common law. Of course, any new exceptions will now need to comply with the three-step test, and Adam mentioned earlier that Section 29 of the Future Relationship Act may have the impact of directly amending certain UK laws, and this is one example of that. Whereas previously the three-step test was not directly implemented in UK law, now arguably it is as a result of Section 29. The parties are also relatively free to set their own laws as to collective management of rights. And while there are no immediate plans for the UK government to bring in any significant changes to copyright in these areas, copyright laws will begin to diverge as early as this summer, as the DSM directive is implemented in the EU, thereby bringing in, among other things, the press publishers' right and fair remuneration rights for authors and performers in EU member states, but not in the UK. With respect to trademarks and designs, while Brexit itself has a significant impact on brands, the TCA doesn't change very much. The minimum standards of protection it sets reflect existing EU and UK laws. Of course, one of the main impacts of Brexit is that UK registered rights will no longer cover the UK. And there are a number of practical consequences that flow from that. Given the time, I won't propose to go through those today, but the team here have prepared a really comprehensive checklist of actions that brand owners should be taking now, and the URL for that is on the slide. Finally, very quickly on patents and trade secrets, the TCA doesn't affect the European Patent Convention, and the minimum requirements for protection of trade secrets essentially mirror the provisions of the existing Trade Secrets Directive. And with that, I will pass back on to Adam to conclude.
Thanks, Yang, and thank you everyone else. I mentioned earlier how EU and UK law are about to diverge because of separate initiatives that each party are introducing over the next at least 18 months. And with apologies to those who were on our Digital Services Act webinar just before Christmas, you'd have seen a version of this pipeline. What I've done here is try to pull together the many pieces of legislation and proposals which are going to have a material impact on all digital services operating in Europe over the next couple of years. So Yang's mentioned the Digital Single Market Copyright Directive coming into force. I think in terms of how services interact with their users and their customers, the Digital Content and Digital Services Directives and the Omnibus Directive, which are coming into force in January 2022 and May 2022 respectively, are going to be absolutely crucial. And they create some material changes, particularly the Omnibus Directive. We're already helping clients plan for that implementation. So I think if Brexit itself weren't all complicated and daunting enough, here's a nice thought on which to end, services that operate in the UK and EU, i.e. everyone pretty much, will need to work out how they can play by those two sets of similar rules, but also very different regulatory regimes, and whether it's possible to find a common approach between them. That's all we were going to cover. So it just leaves us to thank you all for joining us today. Wish you all very best, and wishing you keep all safe and well in these difficult times. And we look forward to speaking with you again soon. And here's what we look like before lockdown. And we wish you well, and look forward to speaking soon. And goodbye.